good afternoon, or whatever time you're joining at. I hope you're having a good time. My name is Chela Faith. I am going to be the moderator for this webinar today, and I'd like to first welcome each and every one of you today. And right before we begin, I would like to make some opening remarks, and then we can proceed with the EAC anthem right before we have each and every panelist introducing themselves. So right before I begin, I would like to thank Kabarak University Press and the Jumuiya EAC Law Journal team of editors for putting together. Okay, I had some background noise for putting together this webinar in our Jumuiya webinar series. This webinar is organized by Jumuiya EAC Law Journal, a peer-reviewed periodical of Kabarak University School of Law, whose aim is to offer scholars and practitioners of EAC law a platform to produce and disseminate their research. To this end, I would like to encourage you to submit your work for publishing into the volumes of the journal. And most importantly, I would like to highlight the fact that the Jumuiya Journal also runs a blog known as Usuli, which welcomes contributions anytime on any subject relating to the EAC, that is the East African community. You can find us on Twitter under the handle Kabu Press KE, KABU Press KE. So throughout this webinar, we're going to have the Q&A function. You can just check it in your Zoom. That is where you're going to make questions and your comments regarding the discussion or the topic that panelists are going to have. So this time I'm going to invite Melissa, who is going to take for the discussion by playing the EAC anthem.
Mungu twaomba uilinde Jumuiya Afrika Mashariki, tuwezeshe kuishi kwa amani, tutimize na malengo yetu. Jumuiya yetu sote tuilinde, tuwajibike, tuimarike, umoja wetu ni nguzo yetu, idumu jumuiya yetu.
Thank you, Ms. Melissa, for the EAC anthem. I would like to proceed by introducing our panelists. And right before I do that, let me introduce myself. As I earlier mentioned, my name is Ms. Chela Faith. I am Kenyan-based lawyer. I am also a trade and investment lawyer, majorly very focused on AFCFTA and its implementation. To this end, I would like to say that this discussion is going to be very interesting, considering where we are with implementation and basically even discussing the flexible integration frameworks which we have as variable geometry. And today's is majorly going to focus on variable geometry and its play in EAC. So today's webinar is focused on examining the principle of variable geometry and its application in trade relations between the community and third parties. Our panelists, who are very esteemed and we're very grateful to have you today, are Dr. Timothy Masiko, Esther Kenda, Professor Thomas Milej, and Professor John Ranga. I would like to introduce each and every panelist right before I ask them to proceed and let each one of them know who's going first, who's going second. So Dr. Timothy Masiko, who's going first, is an assistant professor of the School of Law University of Nottingham, where he is convener of the World Trade Systems module in the LLM program and teaches international law and the global economy, land law, and foundations of thought in the undergraduate program. His research focus is on international economic law, particularly Africa's role in its evolution. He holds a PhD in law from the University of Nottingham, and his thesis titled Flexible Regional Economic Integration in Africa, a historic look at the East African community, has been considered the history of economic integration in Africa and the use of variable geometry to achieve continental integration. For his unique contribution, Dr. Masiko was awarded the CL Hart Prize in International Law in 2020 and was published in the Hart series Studies in International Trade and Investment Law in 2022. His forthcoming research will be on trade, investment, and modern slavery, and will investigate how trade and investment agreements can be harnessed to address modern slavery risks. Thank you so much, Dr. Masiko, for being here, and we look forward to listening and learning from you. Secondly, we will have Professor Thomas Milledge. He is a professor of law at Kenyatta University, where he is the chairperson of the Public Law Department. As the chairperson of the university's Program Development Committee, he was instrumental in developing the Masters of Law program and revitalizing the LLB curriculum. His research specializations spans public international law, regional integration, and comparative constitutional law. Professor Milledge is a career law educator and has taught law at the University of Frankfurt, the University of Cologne, and the University of Islam. He was recognized as the Law Teacher of the Year in 2022 by the Law Society of Kenya's Nairobi Legal Awards for his passion and dedication to supporting his students' progress in and outside of the classroom. He holds a doctorate in law from the University of Cologne and a postdoctoral degree and diploma in European integration from the Jean Moulin University. Thank you so much, Prof, for being here today. We look forward to hearing from you. We're going to have Dr. Esther Kenda. She is the founder of EK Consulting Group, Trade Policy and Trade Law Practice in Uganda, that provides advisory and research services on various aspects of trade law and policy. Her firm has provided its services in key trade law and policy developments across the EAC community, such as the development of the EAC investment framework, the EAC common trade policy, conducting a study on the common external tariff rates on sensitive items, and conducting an impact assessment on the proposed ban on second-hand clothes in the EAC community. She has provided her expertise on trade and regional integration to the Southern Africa Development Community, the governments of Uganda, Kenya, Rwanda, and she is an international trade law expert at the Trade Policy Training Center in Africa. Dr. Kenda is an advocate of the High Court of Uganda and holds an LLM in international trade and investment law from the University of the Western Cape and PhD from Makerere University. Very, very honored to have you, Doc, and we are definitely looking forward to hearing from you and learning so much from you. Finally, we have Professor John Ranga. He is an associate professor of law and the head of the Department of International Legal Studies, Commercial Law and Finance Law at the Tumaini University, Makumira in Tanzania. Professor Ranga served as the founding registrar of the East African Court of Justice between 2001 and 2014, and thereafter was a judge of the High Court of Tanzania until 2017. He was also a founding member of the Faculty of Law at the Tumaini University of Makerere. His research interests include human rights, constitutionalism, international law, and regional integration. He has published extensively on East African community law and is the chief editor of Tuma Law Review and Tuma Journal of International and Comparative Law. He holds a PhD from the University of London School of Oriental and African Studies SOAS. Thank you so much for being here, Prof. We are truly honored and we're looking forward to hearing from you. So at this point, I would like to invite Professor Dr. Timothy Masiko to go first on today's topic. Thank you so much.
Thank you, Faith, and thank you everyone for having me. I am humbled to be here, especially with such a high-profile panel, including Esther, who I don't know if you'll remember this she held my hand and led it into international trade, going as far back as 2010, when she taught me at TRAPCA, where I incidentally now also teach. So thanks once again for having me, and I'm looking forward to a wonderful afternoon with you all. I will be focusing my presentation today on a bit of the background of variable geometry, specifically in the East African community, looking at some of the history that led up to its adoption and eventually its implementation within the East African community. Although it looks like I'll be covering a lot, it's just briefly those 3 items with room for questions at the end. So if I may, let's go straight into some of the conceptual matters that I think might be important for us to understand. For those that might not have a background in international trade law or in EAC law, just a brief history or a brief contextualization. Variable geometry fits within a broader background that also fits within public international law more generally. So within the study of public international law, we have international trade or international economic law, which is my field of expertise, and broadly speaking, the field of many of the other panelists here today. And then within that, we have the study of regional economic integration, and then our focus, of course, would then be flexible integration, or as is more familiar to us, variable geometry. Variable geometry has been called many other things, but broadly speaking, it's all about flexibility. So I say a rose by any other name, as Shakespeare once said, will smell just as sweet. We may call it all kinds of things, whether we call it variable geometry as we do in the EAC and the AFCFTA, or differentiated integration, as it has been in the EU, and I know Thomas will be talking a bit more about that. It's also been called multi-speed integration, overlapping circles. It has about 20 different names and variations, each of which may bring with it some connotations on how it is applied, but some of them usually overlap. There are some common threads, regardless of what name we ascribe to it. But I would like to pick out just 3 of the common threads that apply to, broadly speaking, all forms of flexible integration. The first is that usually there is a common goal and common basic rules, but there might be a differentiation in the way the rules are applied, or a differentiation in the pursuit of those integration goals. So the end goal is the same, or the basic rules are the same, but there may be a difference in the way that they're applied. The other common thread is that stalling, of course, is the enemy. So all progress is good progress, even if it is not progress that includes the whole group or the whole block. So any forward motion is better than no forward motion at all. And as we're going to see, this was the justification in part for the adoption of variable geometry within the EAC, and the attempts to implement it, as we're going to see later in the webinar. And the other, I think, characteristic of stalling being the enemy is that integration of parts is sometimes better than none at all. So this is based in part on what we call the stepping stone argument, which is that if some members of an integration block agree to implement the treaty, then eventually the rest will join or will follow suit. So that that would prevent any stalling. The other common thread is that if you don't like it, don't take it, which is sometimes called a la carte integration, borrows its name from fine dining. If you go to a restaurant and there's a menu and you pick what item you want, leaving out the rest. So if you don't like the taste of chicken, then don't order chicken. and so on. So if you don't like it, then don't implement it or don't take it for your part of the integration. The EAC does appear to have some of those, and we'll be identifying some of them throughout this afternoon. And then coming back closer to home, looking at flexible integration within the East African community, there are three primary principles of gradualism or flexibility within the EAC Treaty, plus one, which, as I'll explain, is not necessarily expressly included as a principle of flexibility. So we have asymmetry, which addresses those variances in the implementation of measures, usually based on the economic differences between the members of the group. However, the purpose remains that we'll be pursuing a common objective in spite of those asymmetries, in spite of those differences within our different abilities. We then have subsidiarity, which emphasizes multi-level participation on a wide range of participants in the process of economic integration. And that will look at things like having us adopt decisions at the region and then going on to implement those decisions locally or domestically. And then finally, or semi-finally, we have variable geometry, which is our focus for today. It allows for that progression and cooperation among a subgroup of members within a larger integration scheme in a variety of areas and at different speeds. And as we're going to see, one of the examples that I'll be focusing on, which was the NCIP, was an attempt by some members of the EAC to rely on this particular principle in order to drive closer cooperation or integration on a specific or on some specific areas, or albeit at different speeds from the rest of the group. And then all these three, symmetry, subsidiarity, and variable geometry, are to be found within Article 7 of the EAC Treaty, which provides for the principles that guide the integration within the EAC. We have a fourth one, which, although it does not appear in Article 7, has been used, and that is consolidation, which starts with basically low-hanging fruits. So anything that is within easy reach or that already existed before the EAC was established, that we can then consolidate to build upon and leading to more refined, larger projects and programs. For example, we initially had some cooperation at our borders. Those have now been consolidated into things like one-stop border posts. We have streamlining of customs practices across the partner states and so on, which will have been taken from low cost or free projects that had that yielded high success. And then there have been different justifications for the use of this flexibility within the EAC, whether it's variable geometry, asymmetry, subsidiarity, or consolidation. And we can put these largely into economic arguments and political arguments. So the economic arguments, if you are familiar with the history of the EAC, we know that the EAC existed as far back as 1917, collapsed for the first time in 1966, restarted in 67, collapsed again in 1977. And one of the main drivers of those two collapses was the disproportionate sharing of benefits of the community. And so to avoid that, we thought if we introduce this principle of flexibility, so that members of partner states can be able to share the resources of the community equitably as provided in Article 6 of the EAC Treaty. There's also the need to distribute responsibilities and costs of integration. This is in part a holdover from the past, because where we had, for example, education, if we focus on education, we had lawyers being trained in Dar es Salaam, doctors in at Makerere, and then a lot of the agricultural training being done in Nairobi. That distribution of responsibility is still sort of continued into the current iteration of the EAC. And then the nature and volumes of trade between partner states will, of course, drive, this is based on the gravity model in economics. Those that trade more with each other are more likely to cooperate on other matters, which, as we're going to see, is in part one of the driving factors for the quick accession of South Sudan into the EAC, which might have been kickstarted by its participation in the NCIP. And then where there have been disparities in export and economic power between integrating states, then we're more likely to have flexibility being included. And we can see that as it has spilled over to the AFCFTA, with 55 members having various export and economic powers. Variable geometry then comes into attempt to remedy that or balance that. And then also, of course, mitigating the effects of external shocks, because if we had uniform implementation, one shock on one of the members would be a shock on all the members. And then more politically, some of them can be the economic ones, because of course most economic decisions are political considerations. However, the overarching goal is to avoid a repeat of those past collapses. And again, as with economic policies, there might be divergent political aspirations, and dealing with opposing sovereignties, which has been especially highlighted in the EAC experience. And then lessons from the colonial era, in which, of course, the EAC having been established as a matter of convenience for the UK, because they did not see a point in having to at the start in 1917, Kenya and Uganda as separate customs territories, combine them for administrative purposes. We learned from that it might be useful for us to treat each other as one instead of multiple customs units. And then also accommodating a wide scope of activities and areas of collaboration. And again, varied capacity, which is closely related to the economic capacity, but also the political will to integrate, which, as we might see in some of the discussions this afternoon, different partner states have different levels of willingness to pursue integration goals. We'll turn our attention now to the NCIP, which I think is a fine example of how to, or more likely how not to, pursue differentiated integration. How not to, because as will become apparent in a couple of slides, there were a lot of things wrong with the NCIP. So I'll start off with just a whistle-stop tour of what the NCIP was. It was the Northern Corridor Integration Projects, which was an attempt to pursue faster integration along certain lines between some parts of the EAC. The where being Kenya, Rwanda, Uganda, and then later South Sudan, and eventually DRC joined the negotiations before the NCIP fell apart. It was mainly driven by the presidents of Kenya at the time, Rwanda and Uganda. So it was a very politically driven rather than structurally or into infrastructure, institutionally driven effort. This mainly lasted between 2013 and 2016. So I have in other forums described it as a firework. It arose very fast, exploded onto the scene, and then fizzled out just as quickly as it came in. The main reasons for it, as we're going to see, fast minds and slow feet. So we had ideals of where we wanted the EAC to be, but our feet were not moving nearly as fast as our brains. And by our feet, I mean being the implementation of the EAC treaty. 2013 was about 14 years after the EAC had been implemented. And from some sections of the community, there was a perception that the goals of the integration were not being achieved as fast as they could have. And the how, it was ad hoc decision-making was effectively, they used to meet, I think, every 2 months or something, make decisions and attempt to implement them. Although it wasn't based within the EAC, there was reliance on Article 7(1)(e) as a fallback or as the authorization for its implementation. And looking at the NCIP as a form of variable geometry, it started as a coalition of the willing. So if we go back to that definition of variable geometry from Article 7(1)(e), which is where some members of the state of the larger group can take decisions based on whether their capacity, their will, and so on. So it started as a coalition of the willing between Kenya, Uganda, and Rwanda, and then later grew to include South Sudan, even before it joined the EAC. The focus was mainly on tourism, liberalization of services trade, especially the free movement of persons, and infrastructure. So tourism, we had things like the East African tourist visa. So a visitor from outside the EAC could visit Uganda, Kenya, or Rwanda on the same tourist visa without necessarily applying for separate ones for each of those. Free movement of persons, we had some motion, but not that much. I think perhaps the most outstanding was the ability to travel across the borders of the 3 countries with national IDs rather than needing a passport. And then infrastructure, of course, there were things like the standard gauge railway, which was pursued a bit aggressively, but applied differently in the different countries. I will not go into the reasons for that. And then, of course, the pipeline from Uganda's oil fields in Western Uganda, which eventually, ironically, led to the collapse of the NCIP. And then there was no constituting document or established structures. As I said on the previous slide, it was ad hoc, organized primarily around the presidents of these 3 countries. And although it was not a parallel institutional bloc, it was not expressly under the EAC. It had no formal ties with EAC structures, with the result then that it had no real belonging or real ownership other than the heads of states of the 3 countries involved. Reasons for its rise, again, political and economic. Many of them were just matters of practicality. There was difficulty in reaching consensus on some integration activities and then overlapping memberships. Tanzania at the time, and still is, a member of SADC, and it was felt within the EAC that sometimes Tanzania was prioritizing its SADC commitments over EAC commitments. And then we had the M23 uprising in Congo, mostly in 2012 and 2013, which is around the time that the NCIP started. That, of course, is still ongoing. And then we had different national priorities with regard to integration. So for some members, infrastructure was a priority, while with others, it was more economic harmonization and so on. So NCIP came in sort of to fill that void in or to address those disparities in priorities. And then from the more economic, we had the Northern Transport Corridor, so linking at the time from Kigali to Mombasa. And then, of course, the standard gauge railway that was pursued, built up to Western Kenya. Different reasons that I will not go into, it didn't quite take root in Uganda. And then, of course, Tanzania's concerns with land and mineral deposits, especially around things like freedom of movement and whether that meant that there would be establishment, rights of establishment, rights of ownership for non-nationals as far as things like real estate and so on were concerned. And then there were varied levels of openness to the free movement of persons. So again, some countries were more willing to open their borders within the region, while others were not so keen. And then what I've broadly called the South Sudan factors, of course, there were the political issues that Sudan was facing around that time, including their push for independence, and then following their secession from Sudan, they had quite a few political upheavals, but more on the economic side was simply the fact that South Sudan was one of Uganda's biggest trade partners and was also a significant trade partner for Kenya. And so there was that need to streamline trade with South Sudan in a more mutually beneficial way. And then finally, the things that led to the fall of the NCIP, the absence of rules and structures. As I said, it was an ad hoc institution dependent on some level on the mood of the three presidents that were spearheading it. And without rules, without structures, any international cooperation is not likely to thrive. And then, of course, there were tussles with existing EAC structures. At one point, there were questions as to whether some decisions were EAC decisions or NCIP decisions, although it wasn't clear what exactly NCIP was. And then high running costs, because they decided they'd be meeting every 2 months, and organizing a meeting of heads of states that frequently, of course, comes with a lot of costs. And that also meant that there would be even more meetings at the technocratic level, which was not being, because of the absence of those structures and institutions, there was no direct budget for it within the three partner states. And then, as I mentioned earlier, ironically, the Uganda-Indian Ocean oil pipeline, which led to ultimately the demise of the NCIP, because there was a lot of speculation that it would go through northern Kenya, or central Kenya more correctly, and then last minute it shifted to the southern route that it is now projected to take. And that then led to a collapse of trust between the parties, with the result that what seemed like a closer cooperation was not exactly going to happen. However, again, also kind of ironically, that desire to save the EAC, because of the realization that a focus on the NCIP meant we could not focus on the EAC as a bloc, meant that the NCIP had to be put on the back burner so that we could focus on what we deemed, by we I mean the EAC, deemed as a greater or more important project. And so what does the EAC look like today following the NCIP? We still have the EAC Classic. So Uganda, Tanzania, Rwanda, Burundi, Kenya and Burundi. Burundi still being almost sidelined, but not nearly as much as especially the newer members. So South Sudan edging closer and closer towards the center, mainly because of its trade ties with Kenya and Uganda, and then the DRC getting also just as close, nearly as close as Burundi, primarily based on its political interactions with Rwanda and Uganda, and then the Federal Republic of Somalia, which is, of course, a more recent entrant, and still making its way towards the center. I will end my presentation at that point. Of course, there will be an opportunity for questions later, but thank you all for listening, and I look forward to all the questions that will be arising.
Thank you so much, Dr. Masiko. I mean, it's a very insightful discussion we've had here. And as I was taking down my notes, I'm sure that so many questions we're going to have. And we can do that to everyone who has a question. You can use the Q&A function right at the bottom of your screen. Please utilize that, and then we can have the questions there until I'm buffering. Can you hear me, Doc? Okay, thank you.
Yeah, I can hear you. Yeah.
All right, thank you so much. I'm going to invite Professor Millet, but right before you come in, Prof, I would like to acknowledge the presence of very important persons in our webinar today. I would like to acknowledge Professor Chidi Odinkalu, who is in attendance, and he is a professor at the Fletcher School and was in the previous webinar. Also, very important that his PhD was on. You're welcome, and we're very grateful to have you today. I'd also recognize and acknowledge the presence of Indra Mutai, the director and CEO of the School of Law, and whose PhD and this is also in trade law. So very much welcome, Henry Mutai. I would also like to acknowledge and invite the presence of Honorable Finalis Okubo, who is the immediate former registrar of the Eastern Court of Justice. We would like to invite you and acknowledge your presence today. I would also like to acknowledge Advocate Charles Munywa from the Senate of Kenya. Munywa is in the Justice and Legal Committee of the Senate as the clerk. We are truly honored to have you today in this webinar. Finally, I would like to acknowledge Advocate Tom Ongeri, who is a senior partner at Ongeri, Omiti and Bush Advocates and the head of private law at the Catholic University of East Africa here in Kenya. Thank you very much for being here with us, and we look forward to your questions, comments, and your participation in the webinar. I would like to therefore invite Professor Thomas Village to carry on with us. You're welcome.
Thank you. Thank you very much, dear Faith. Thank you very much for the invitation. It is always an honor to speak to such a distinguished audience. I'm also very honored to be invited to speak today by the Kabarak University Press, which is doing God's work in East Africa. So after the rigorous analysis, an impressive rigorous analysis by Dr. Masiko, mine will be more of an oral essay about variable geometry. And I would like to start with a very crucial distinction for me, namely distinction between three things. Number one, the variable geometry, and Dr. Masiko gave us the definition. Variable geometry, namely the fact that different states engage in different forms of cooperation. So variable geometry is a fact. Then there is a principle of variable geometry. And third, the ideology of variable geometry. And this is where I have my concerns. But I will start with the variable geometry as a fact. And this is what is happening in the European Union. And I am apologizing for wasting your time by talking about the European Union, but it is quite interestingly regarded as a sort of a precursor of variable geometry. And even the East Africa Court of Justice, in its advisory opinion on the variable principle, the variable geometry, dwells extensively on the example of the European Union. So definitely, yes, there is some sort of variable geometry in the European Union. I will give you various examples of that. So number one, there are accession treaties. In 2004, a number 10 new member states joined. And within this enlargement process, accession treaties were concluded, and those accession treaties provided for transitional periods. For example, by virtue of those accession treaties, the so-called old member states retained the right to limit the access to their labor markets for the citizens of the new member states for up to 7 years. Some member states did, others did not. Interestingly, UK did not. Then the most famous one, the monetary union, there was a permanent opt-out from the for the United Kingdom, which is now obsolete, and a still relevant one from Denmark. It is operationalized by treaty law, yeah, so by protocols to which all member states of the European Union are parties. Yeah? Sweden joined the European Union in 1995. The opt-out is secured, permanent opt-out, yeah, is secured by the accession treaty, again, treaty law. Poland, Czech Republic, Hungary are under the obligation to adopt the euro, but are not doing so, yeah, because there's no political will, and they're also not fulfilling the criteria, the convergence criteria, but they also don't want to fulfill them. So, in addition, I'm still talking about the monetary union, we have some additional treaties, so outside of the framework of the European Union, which were adopted in the wake of the Greece crisis, or debt crisis in 2008. We have, as of now, the European Stability Mechanism of 2012, which is a separate treaty framework. Then another one, Schengen Agreement. It was initially a separate agreement. UK, Ireland were not parties when the Schengen Agreement was incorporated under the framework of the European Union. There were also opt-outs for them secured by a protocol. Then we have some non-European Union non-European Union states who are members of the Schengen area. And this is also secured by treaty law, yeah? Classic international law. Those are the associations agreements between the EU and, for example, Norway and Iceland. United Kingdom had most opt-outs, yeah. Other opt-outs, even more opt-outs were secured or guaranteed for the United Kingdom should the British people decided to stay in the European Union, but they decided not to. Then there is something called enhanced cooperation, which is different to the cases which I have discussed in so far, because this applies not to the treaty law, but this applies to the law made by the EU organs within the treaty framework of the European Union. And it may be established according to the current treaty provisions by at least 9 member states as a measure of last resort. If there's a project and the member states try to agree, but they cannot agree, so consensus cannot be reached. There are procedures for that, last resort. Yeah. And it must show a positive effect on integration. It's very important, yeah, that those enhanced cooperation must show a positive effect for that cooperation within the entire European Union, and it must be open for all member states to join in the future. It is not used very frequently. It's been there for years, if not for decades. There are 5 cases as of now. Perhaps the most famous is the European Public Prosecutor's Office. There are, as of now, 3 opt-outs. Denmark is not a party to this initiative. Ireland and Hungary, Poland was not, but after the right-wing populist government was kicked out last year, Poland rejoined. So this is what the kind of a variable geometry in the European Union. But and what do we learn out of that? Yeah. So we learned that generally there are very different forms of differentiations of the integration process concluded at very different moments in history, using very different legal forms to pursuing very different objectives. There's no blueprint, no consensus, or no consensus on how this differentiation should be handled. There is no guiding thought. I would say the best word which would describe variable geometry, not the principle of the variable geometry, but the fact that there is variable geometry, is ambivalence. Ambivalence. Generally, it's quite interesting that the EU law always puts premium on uniformity of application. If you read European Union literature, say, yeah, we must have a uniform market and the same rules applying to everybody, while outside of the European Union is regarded, as I said earlier, precursor of variable geometry. Yeah, it's interesting because perhaps there is a difference between what the European Union wants to be and how the European Union is perceived outside. Yeah, so it is something to think about for Europeans, also when it comes to immigration policy and human rights, but story for another day. What we have seen is that when it comes to EU law made by the EU organs, the treaty framework is quite inflexible. So there is the so-called internal inflexibility, but there's external flexibility. So we have seen those accession treaties, opt-outs, European Stability Mechanism. Yeah. There are some concerns about this flexibility. So there is the main concern, which is especially voiced in the so-called new member states, is that this flexibility may exacerbate the already existing split between the core and the periphery. Yeah, the old member states and the new ones. Yeah, so that the most powerful states may hijack the integration process and leave others behind, as was the case in Burundi, what Dr. Masiko was referring to. Yeah, but what I want to say is that the EU experience does not deliver any evidence that variable geometry works better than the lack of variable geometry. And if you look at Brexit, yeah, and if you take into consideration that UK was the country with the most opt-outs, yeah, it rather points to the contrary, that we should actually try to avoid variable geometry. But as said, ambivalence for me at best. Just give you one more example, which is quite interesting. The opt-out from the monetary union, which was secured by Denmark in 1992. Denmark rejected the Treaty of Maastricht in a referendum. Said we do not want the Treaty of Maastricht, and one key issue of this was euro. Yeah, the common currency. And now what the European leaders did, rather than saying, okay, look, Danish people, you are right. Let us go back. Let us go back to the drawing table. Let us see how we can make the Euro monetary union work better. Yeah. They said, oh, well, we continue with what we have been doing, but we give the Danish an opt-out. So looking at what happened in 2008 and looking at trade imbalances that we are having now, and some sort of unhappiness about the monetary union, especially in Italy and Spain, perhaps the solution to adopt variable geometry was not a good one. Was not the solution that should have been adopted. Just a fruitful thought. Now I come to the principle of variable geometry. It is a principle which is quite narrowly tailored, and the East African Court of Justice was quite, innovative. Yeah, and I'm very much looking to Professor Ruhangisa's comments on that one. Because the court limited the applicability of this principle to the implementation of decisions and not to the decision making. Yeah? Basically, this principle says, according to the court, that those who do not implement the decisions will not be penalized. So that's the directive content of that principle, while others who want to implement may go ahead, which is quite funny that you have a principle that allows states to implement decisions. Yeah? But it is not, and this is, I think, the point which the court is making, it is not about allowing a group of states to make decisions, excluding other states. An example of the application of this principle of variable geometry is the EPA, Economic Partnership Agreement. It is a treaty now, there's a treaty between EU and Kenya. And this treaty is basically about an implementation of another treaty, which is a treaty between the EU and the member states of the partner states, sorry, of the East African Community, which was concluded in 2014. So Kenya was allowed to go ahead implementing this EPA, and it went on to conclude another treaty with the European Union. There's some controversy whether it is within the framework of the principle of variable geometry as defined by the East African Court of Justice. Anyway, this move was allowed by the summit. Yeah, there's in 2021, there's a summit conclusion, paragraph 9. Yeah, paragraph 9 states that Kenya is allowed to start the implementation of the EU EAC EPA under the principle of variable geometry. Yeah, we have also this principle of variable geometry in not just in the EAC, it's quite common. Yeah, we have it, for example, in CARICOM, yeah, in the Community of Caribbean States. There's Article 27 and 4 in the treaty establishing CARICOM common market, which allows for permanent opt-outs, and there's another article which allows for accelerated implementation of some common market freedoms before the agreed deadlines. So this is it, the principle of variable geometry, quite narrowly tailored, yeah, offering some leeway to the states for implementation. Now, there's also an ideology of variable geometry, and this is something which worries me. Yeah, ideology is basically saying that variable geometry is a good thing. Yeah, but it is something which should be promoted. It is something which should be endorsed. Yeah. Now, if you look at the treaty framework of the East African Community, especially the Customs Union Protocol, there are some provisions which would allow for variable geometry in certain areas, for example, states of application, yeah, or conclusion. Council Osiemo can say something about it, perhaps, conclusion of trade agreements with third states. Yeah, but the principle of the ideology of variable geometry would basically, would be number one, materialized in those particular provisions. But number two, it could be living the life of its own. Yeah, and number three, it would inform how those exceptions, yeah, in the Customs Union Protocol are handled. And I see that my time is coming to an end, so we'll just focus on one thing, which is a source of worry for the business community, namely the stays of applications. So there is a provision, yeah, in the Customs Union Protocol. I will read you out. That is Article 12, Subarticle 3, which basically says that the Council may review the common external tariff structure and approve measures designed to remedy any adverse effects within any of the partner states and so on and so on. Yeah, so what it basically says, it's the Council may allow for exemptions from the common external tariff. And according to the recent information from the East Africa Business Council, in 2024 and 2025 financial year, there are 1,956 tariff lines under states of applications. Uganda takes the lead with 901, Kenya with 816, Rwanda with 116, and so on. Yeah, so there is an exception, and we say, well, we endorse variable geometry. The Council keeps granting those states of application, and there is a worry that these numerous states of applications erode the customs union as we have it, as a common external, the common external tariff. Then we have the Strategic Trade and Investment Partnership, which Kenya is negotiating. I have gone through what has been written about that and the TIFA. Yeah? Luckily, nobody had the idea to justify this Kenya-US free trade deal with variable geometry, so it's better shut up so that nobody has that idea. Finally, I'm also concerned about the rule of law. Yeah, so we can, of course, say, well, the rule of law is a post-colonial neoliberal project and so on. There's, of course, some reason behind that, but the rule of law, yeah, and in particularly the operational principles, the fundamental operations principles of the community, the uniformity of their application has proved to be a key advocacy tool and mobilization tool, yeah, for human rights, for democracy, against marginalization of communities within the EAC, especially in the states in which the judiciary is not as assertive as in Kenya. I'm worried that endorsing the ideology of variable geometry, promoting it, would can be abused to justify not living up to standards, or outrightly non-implementation. Like, just giving justifications like we are not yet ready or we have unique challenges. And I'm really even concerned that the recent admission of the DRC and Somalia with very little scrutiny, especially if you compare it to the scrutiny which was applied when Rwanda and Burundi were joining, was done with this idea in mind, that the shortcoming in the preparedness of those two states can be justified or made up later with variable geometry. Yes, let us then join, but they do not have to implement everything immediately because there's variable geometry. Watering down of standards, this is my concern. To conclude, variable geometry is okay. We may, argue how much of it we want to admit. Principle of the variable geometry is also okay. The East African Court of Justice limited, it to implementation of the decisions rather as opposed to decision making. But this ideology of variable geometry, promoting variable geometry across all areas, enlargement, states of applications, conclusions of trade treaties with other states, that might lead to results which would not be satisfactory. What I would suggest, while flexibility is useful and necessary, there should be a framework, for variable geometry, which perhaps should be more elaborate than it is now, so that the partner states make a decision, a strategic decision, how much variable geometry we would like to have, so that we can avoid the medicine. Flexibility is a medicine to inequalities, which are there between partner states and non-partner states. But we should not be applying the medicine overdose. I have a dream I have a dream of a community act. No, not a community, an act of the community, enacted, discussed, debated in the EALA, with public participation, with involvement of national parliaments, of the civil society, East African Business Council, and that this act provides some framework for the use and application of variable geometry within the EAC. And I will stop here. Thank you for your patience.
Thank you so much for very insightful conversations that we've had. And I mean, listening to you, Prof. Thomas, you make me, ask myself questions like, really, if we had a particular framework for the variable geometry, there could be less demonization of variable geometry in the EAC. I mean, there could be more of applauding what variable geometry has done in terms of flexibility, in terms of helping states move, in the same speed, uniformity sort of thing. And I mean, how you ended your presentation, it's amazing. It's really way to go. And I'm sure it sets the place for Dr. Esther Kenda and Professor John Ranga, who are going to be our next panelist in probably less than 40 minutes. We are very excited to have you talk about, other manifestations of variables in the EAC, the challenges that have been posed, different from what Prof. Milledge talks about it being a tool of development. What are there abuses of power? Right then, we will move to how we can maybe use variable in a way that has within the EAC. And right before I invite Kenda, I would like to acknowledge the presence of Advocate Maradi Johannes from Tanganyika Law Society of Kenya. I would also like to acknowledge the presence of Emmanuel Sebijo, the Dean and Faculty of Law, International University of East Africa in Uganda, and was also a former panelist. I would also like to acknowledge the presence of Professor Mani, Professor of Practice of Journalism at Pan University's Graduate School of Media and Communication here in Kenya. And finally, not really finally, and I would also like to acknowledge the presence of Harrison Gori and Professor John Ambani, who are editors-in-chief of Jumuiya Community Law Journal at University. We also have Caroline Mollel, an legal and human rights, and Miss Bibi Speciosa, Director, General Civil Litigation Services, Ministry of Rwanda. We are happy to have you today, and I would like to invite Esther to carry forth. Dr. Esther, can you hear me?
Yes, I can hear you.
Yes.
Okay, I struggled at first to hear you, but I think now I can hear you. Being a lecturer, I am going to pursue this subject according to how lecturers think, okay? I'm thinking of variable geometry as a marriage. Look at it like a marriage. Husband and wife, they've come with children. They each have children. Maybe one has 2 children, one has 3 children. It's a blended family. They come together. Is that a good thing? Is that a bad thing? Can we make it work? Or should we say every couple must come individual, and they must all move at the same pace? So that's how I look at this question of variable geometry, that each country is a sovereign state. It has its dreams, its desires, political goals, political pressures, but at the same time, you benefit better as a bloc. Because, for example, if you're presenting, for example, how the EAC presents its offers at the CFTA, they present them as a bloc. So it stands a better chance as a bloc. It has a bigger market, but at the same time, Uganda has its own personal interests. So let us look at the key features of variable geometry in East Africa so far. There are about five general categories, that we've approached, we've used in East Africa. We've used the differentiated integration. where member states dig deeper depending on their interests. And there you find the tourism visa, where Rwanda, Kenya, Uganda decide for them they are going to have a free visa amongst themselves. That is a deeper integration, differentiated deeper. But then we have also the multi-speed. The second type is a multi-speed integration, whereby countries progress at their own pace. So you find Kenya, which is ready to conclude the EPA, it will go ahead and conclude the EPA. But that doesn't stop the other countries, Burundi, South Sudan, from sitting back. I mean, they are not ready, so they should sit back. So it facilitates that. Just like in a marriage, I mean, some people are able to go further because they are maybe more educated at the time of the marriage, but doesn't stop the other one from letting the other go. Sectoral cooperation, the third type that we've seen in East Africa is sectoral cooperation. They choose which sectors they want to be involved in. For example, again, the tourist visa comes into play, or the transport sector. They've not done, they've chosen which sectors they want to do variable geometry in. The fourth one is flexibility membership. So here again, we find that even if EAC operates as a bloc, variable geometry allows countries that are ready to deepen integration. Again, we see the EU EPA. Kenya is ready, it moves ahead. When Uganda gets ready or Tanzania is ready, they can still go ahead, but doesn't stop whoever is ready from going ahead. And then the last type that we see in East Africa is where there are capacity differences. And here you're recognizing the varying capacities among the EAC member states. And you're saying some, for example, like Burundi, are not yet, in terms of capacity, they need a lot more capacity than, let's say, Kenya. So those that have more capacity move on, and those that don't have a good enough capacity, they wait on. So what are the advantages that we've seen of variable geometry? What are the advantages? Of course, the first one is flexibility. There's flexibility of implementation of whatever it is the marriage wants to achieve. Because at the end of the day, this marriage is going to be successful. Yes, there are different children from different spouses, but it's a blended family, and it's going to be successful. So it allows flexibility. If one child of one marriage is slower than another, the other should proceed. They should not let the other one back. And then another benefit is that it allows inclusivity. It allows some countries to participate deeper, while others are not able to. Otherwise, we cannot all stop and wait for, let's just say, DRC to get to the level that Kenya is. I mean, then what's the point of the integration? So it allows inclusivity, that those who are able to, they move. Those who are not able to, they will come whenever they were. Then it also allows gradual integration. You can integrate gradually, Not everything has to be at next speed. If you're not able to, you're not competent, you're not ready, it allows for gradual integration. Nations can achieve deeper integration at their own pace, whereas their citizens are benefiting without rushing and opening the market for a country that is not yet ready to do that. So it allows for gradual processes. And then it increases cooperation, it enhances cooperation. It enhances and collaboration between countries that are ready and willing to move forward. That's why you see a tourism visa. Those ones can move on because they probably have the same tourists, There are gorillas in Rwanda, there are gorillas in Kenya, there are lions in Kenya, in Uganda, there are lions in Kenya, there are lions in Uganda. So it allows them to work together, even if the others are not ready to do so. It's a benefit in that way. And then there is it avoids uniformity constraints. In traditional integration models, the requirement for uniformity, it prevents innovation and progress. Some countries are ready to innovate, other citizens are innovative and they're progressing. So you cannot sit back and wait for everyone to get on board. And it also makes dispute resolution easier. When countries commit to different levels of integration, the likelihood of disputes may reduce, because not all countries are subjected to the same obligations. There is greater political feasibility. And you find that in regions where political consensus is hard to achieve, variable geometry may be politically feasible. You might find that all the EAC partner states are not able to come to a political consensus, but those who are willing can move ahead. Now, in conclusion, I want to talk about the disadvantages. As a lawyer, you have to look at both sides of the coin. You cannot say one thing is better than the other. So you must look at both sides of the coin. What are the disadvantages, or what disadvantages have been seen? Of course, there's inequality among the members. You find that some are moving very fast and are benefiting greatly, while others are not. It can lead to disparities in benefits and influence. Countries that integrate more deeply may gain better advantages than those that don't. You find that the tourism visa maybe makes it easier for tourists to come, come the 3 countries. And because Tanzania is not part of the tourist visa, so it loses out. So that is there and it's a cause for alarm. And then there's fragmentation of integration efforts. I mean, if you're trying to integrate and move together, now it fragments the processes, you know, it makes it a bit difficult. The other issue is there's complexity in decision making. Of course, there's difficulty in managing varying levels of commitment, which can complicate decision making processes. You know, you need to accommodate what UDRC is saying, then you need to accommodate what the other is saying. So all people, you know, there's complexity in decision making. Then there's potential for club mentality. You know, that the top three or the lower three or the other three, you know, there's that club mentality comes into play. Yet it's an integration. You're supposed to be working together. And then there is risk of ineffective initiatives like that, what Timothy was talking about, how it failed in 2016. You know, they rushed, they went on, they left everyone else, and oops, the pipeline made it impossible. So there's risk of ineffective initiatives. And there's also difficulty in managing relations because, you know, balancing relations between different groups of countries based on their levels of integration, it presents diplomatic challenges. You also find that it's hard to incentivize the people who are not participating. If Burundi is left out all the time, they give up, they lose interest, they don't want to participate, and you need to incentivize them all the time. So those are some of the challenges I have found concerning variable geometry within the East African community. I'll stop there and leave room for my colleagues to add to the discussion. Thank you.
Thank you so much. I mean, it's mind-blowing to hear what you have to say. And I think part of my brain agrees with a lot of the things that you're saying. Can you hear me, Doc?
Yes, please.
Yes, thank you so much. So right before we have Professor John Ranga, I would like to insist and say that there is the Q&A function right below your screen. So if you have any questions, we would like to take them from there. And still, if you would like to have your voice heard, you can go ahead and raise your hand at the end of Professor John's presentation so that we can take your questions from there. Professor John, I would like to invite you to give your comments and remarks on our topic. Thank you.
Prof, I think you're muted.
Prof, you're muted. Please unmute your mic.
Oh, I thought you were the one who muted me.
No. Now we can hear you.
Yes, I just unmuted. It's my pleasure really to be available for this brainstorming, the exchange of ideas, to share with you the little I know about this particular topic. Thank you for inviting me, and I feel honored to be among the people presenting this topic. Good enough, can see distinguished, renowned authors, presenters in this area of regional integration, East Africa in particular. Well, it's also very interesting, and this was my concern at the beginning, that when you are the last speaker, it's always very tricky and difficult to find what has been left. I tried to look at the gaps, but there are so many of them I can pick here and there and probably be useful at the end of the day. You will excuse me for sometimes being repetitious on matters that others have already said. Looking at the various presentations, this variable geometry, as even presented from the treaty itself, raises a lot to be desired. It is one of the principles that are specifically provided under Article 7 of the treaty to guide the achievements of the objectives of the community. But this treaty remains as it was when it was thought of. Until today, it has never been unpacked. It is like a constitution which provides, selected and itemized areas, but leaving it at that for people to sit down, to speculate, to interpret, to give their own meaning. This is what I see here. And Professor Thomas rightly pointed it out. We have variable geometry, open as it is, capable of being abused, and without having a specific, a clear, formal, what should I call? A formal structure, formal interpretation, formal guidelines on how it should apply. We should expect more of coalition of the willing. Those who are likely to happen, and these are whimsical reactions. Those who sit together, they think they have common interest, they quickly arrange to sit and agree on something out of whims, which do not lead them anywhere because there are no guidelines. The first thing the treaty should provide is sit down and tackle it in areas like this. How should this principle of variable geometry apply? I'm looking for a solution. It is a good one because it is even more important now when the membership has enlarged. They started with 3 early member partner states. Now we have enlarged it to 8. Difference in ideologies, difference in thinking, even differing in arguments is eminent, very, very likely. But when you differ, you don't have something to guide you, then whims takes over, they come in place. We become whimsical. At the end, these so-called applications of variable geometry, once employed, do not lead them anywhere. You see what happened to the coalition of the willing. You look at even what Timothy was telling us, Masiko was telling us about NCIP. How did it end? Because there were no guidelines. Personal states' interests, which have no sufficient research, at the time they are like colleagues, they are friends. When friendship soars, things get disarrayed. This is what we should do. And I think Council of Ministers should consider this seriously, including the Secretariat as the thinking tank, should move these things and table them to the Council of Ministers, which unfortunately is not willing to legislate. I'm coming to you, Professor Toma. The Council of Ministers is not willing to legislate for the community. They don't bring the bills until members of EAR get frustrated. They bring out private members' bills, which they themselves have no capacity to implement because they cannot fund some of the projects or the legislation that they put in place. Council of Ministers, you remember the case of, was it Christian Rumwatera? They had even hijacked the private member bill. And when they released, they took it, they never returned it. When the court said, no, Council of Ministers, this bill does not belong to you, return it to Yara for continuation with the legislation. Because for them, they had seen that protocols are enough. We don't need to legislate. I'm attempting to answer Professor Thomas's concern that we need guidelines. Now, it's a case of who rebelled the cat. Who should now take initiative? Bills should originate from the Council of Ministers. But for the Council of Ministers, when they look at protocols, for them it is enough. They don't even need legislation. How do you implement? How do you enforce a protocol? That remains to be an issue. And this is a situation that EAC is facing. The variable geometry, good as it is, it allows the flexibility as a principle, but its implementation has already given us unfavorable and present results. And we expect more to come, especially now that the number has enlarged. And the number has enlarged without a clear scrutiny of membership. It is a condition of the treaty that there has to be peaceful coexistence before a member among the partner states. Now you are aware that Rwanda and the DRC are not peacefully coexisting even before joining or being admitted to the community. what do you expect after joining the community? Did they even have qualification to join the community? Then when imagine a principle of variable geometry being applied in this kind of situation, what's going to be the results? It is a failure before you even start. I even looked at a situation where Rwanda and Burundi joined the East African community. At that particular time, they were not in terms. They were not looking at each other in eyes. And it is a condition. To have variable geometry, you need to be speaking at least in a certain agreeable situation, but they are not. Treaty remains solid, intact, and defined as it is, and nobody is prepared to unpack it. A brilliant idea by Professor Tom, a brilliant idea by Dr. Timothy, a brilliant idea by Dr. Katenda. I saw you, I could see you were concerned as an academician, but let's look at the back. Who is going to do all this? There are so many things. Even the principle of asymmetry needs to be unpacked. Who is going to unpack it? There are so many things that we need to be worked upon, and still the idea we say at least the civil society should be consulted. Since when has it ever been consulted? When even when the treaty was being negotiated, the civil society is just they are given observer status. The business community is given observer status. All these civil societies have observer status. They are observing what is going on. There are actors there, and for them, they are observers. So you observe what is happening. That is where we have to start. A treaty itself has to be amended, has to be involving. It is called a people-centered and the private sector driven. But I don't see it anywhere in reality. They are just on papers. When it comes to reality, there is nothing like people-centered. People are not there, but they are observers. The highest level they can achieve is being observers. Like we are discussing as academics to steam out, to vent out our concerns. And this could probably be the end. Who cares? Do you have any platform or somewhere to be heard among the structures of the community? Fine, we are doing our job, we are academicians. And sometimes they don't even know this people-centered or this variable geometry. Partner states don't know what exactly it means. I could read it from President Kikwete's concerns to the National Assembly when he was accusing, when he was Burundi and Burundi, they were sidelined. For him, he was bitter that we are being sidelined. But there is variable geometry. And Uganda, Kenya, and Rwanda invoked in variable geometry, which led them nowhere. So it's a principle of convenience, applied conveniently and does not lead us to anywhere. I can go on and on until cows come home, but this is the reality where we needed to look at least to start somewhere. The treaty, since it was created, it was only amended twice. And every time it was amended, that did not concern itself with these matters. It was amended, sometimes surreptitiously, to put it in the language of East African Law Society when they were challenging these amendments arising from the case of Anyang'anyong. Quickly, 15 days, it was amended. People were not consulted. And when the Law Society attempted to, to protest or to raise concern, to block it, the story can go on. It is a long story. So let me open up at least by expressing this concern. How do we proceed? Having identified all these challenges and, variable geometry as a principle originating from gradualism, which is key in any integration, regional integration. When we go back to the Abuja Treaty, that principle of consolidation, which Dr. Tom was referring to, I thought it would come to play at the end when regional economic communities would have come together as building blocks. Then they consolidate their relationships, what has already put in place. But instead, the Abuja Treaty, the agreement is now soon coming over. Nothing has been attained or achieved. We are still disintegrated, divided even than before. I can rest my case for that for now, and then allow at least these participants can also come in. Thank you, Faith.
Thank you so much, Prof. It's very interesting. I think I've been nodding my head the entire time you were speaking because, you know, I share the same concerns as you do with EAC and even AFCFTA, them having variable geometry, and even looking at the question of our you know, like Council of Ministers, do they know what variable geometry is? Do they know what the consequences are having variable geometry as a flexible integration framework? And what Professor Thomas mentioned and Dr. Katende on having variable geometry and its framework. Do we have conditions? Are there conditions such as, you know, having human rights? A country should, you know, respect human rights before they join a certain regional economic integration network, for example. And it raises so many questions and very many concerns. And I would like to thank you all for your comments, your participation, your very insightful thoughts, and would then seek to proceed with questions and answers. And from my end, I can see we have, so first I will take Dr. Timothy Masiko, and then I will take Lewinsky, who will be next with the questions. You're welcome, Dr. Timothy.
Thank you. Now, I'm just going to very quickly try to avoid repeating what my colleagues have just said, but to emphasize some of the main issues. One, all three have clearly highlighted the need for a clarification on how variable geometry should apply. Shameless plug at this point, a couple of years ago, I put together a small pamphlet talking about variable geometry in the EAC and concluded that by proposing how I would draft a provision on variable geometry, which included things like limitations on whether it was on time or on scope, the prohibition of certain forms of flexibility, and the exclusion of certain parts of the treaty from being subject to variable geometry. And I share Professor Rangisa's frustration. Academics are not particularly listened to where we need to be listened to, because that doesn't appear to have caused the waves I was hoping it would cause. But then secondly, and this is something that Faith just alluded to, the nature of variable geometry, especially within the African context, does not look like it is likely to improve. And I say this because if we look at the AFCFTA's adoption of variable geometry, it is not even defined within the AFCFTA treaty. And there's a good reason for that, or at least in my thinking, that is something that is significant, because it seems like the AFCFTA has, or at least on the African level, on the continental level, we've got to a point where we think variable geometry is something that does not even need definition anymore. We all know any treaty, statutes, even domestic regulations will usually have definition or interpretation sections for key principles. But at the AFCFTA, we've now accepted variable geometry as it is, without even needing to define it or delimit its application. And that, I think, is quite dangerous for the very reasons that my colleagues have very eloquently put forward. And I will shut up now.
Thank you, Doc. Thank you so much for that clarification. I will then invite Lewinsky Imuhira, whose hand is up. Lewinsky, are you ready? I see Lewinsky's microphone is on.
Can you hear me? Can you hear me?
Yes, yes.
Oh, okay. Thank you, Faith, for this opportunity, and thank you to the panelists. That was a very eye-opening discussion. So from this side, my comment is that the principle of variable geometry, in my view, it's a very good principle because it allows flexibility in development. I understand that Dr. John and even the others have raised concerns on like they've raised concerns on that if this principle is implemented, then what about consensus in decision making and all other things, that peaceful existence, that they've raised those challenges that are there. Yes, we are so cognizant of that fact, but I think the most important thing in any regional integration is that these countries should economically grow. And as a matter of fact, Kenya, Uganda, Tanzania, and even other countries that are in the East African community cannot grow at the same pace. And if Kenya has an ability to implement a certain project that may do well for the economic growth, then I don't see why Kenya, probably Kenya, Rwanda, just this example, Kenya, Rwanda, Uganda can come together and you know what, I use this principle at least to implement that specific project that they want to, that they have first they have the capacity to implement it and to actualize it in their countries, as others will slowly follow into implementing the same project. So in as much as there are challenges to it, if you look at the flip side of it on how countries with the ability to grow or their economic muscle to grow can easily take advantage of this principle and grow, then it realizes that it can eventually influence the other countries that, it can eventually influence like general development of the whole East African community. That is in terms of, that is the economic growth of the East African community, so that we have more countries quickly developing and others can easily follow. And maybe later on, because I'm seeing amendments are being proposed, I'm seeing consensus in decision making is being proposed, eventually somewhere these countries can come to agree on, you know what, we can help each other grow in this and this in this manner. We've seen Kenya has implemented this. What can we do now to ensure maybe Tanzania or Rwanda or Burundi now can come to be at par with Kenya? So I'm still of the view that it's a good principle, even with its defects, with its pros and cons, and automatically there's no principle that is 100% perfect. So I'm still pro variable geometry. Thank you.
Thank you so much, Lewinsky. I mean, I hear you, and I think the right person to address this would either be Prof. John or Dr. Esther. Based on what you said earlier, you kind of spoke about, having this framework, like, can we have a framework that maybe covers the application of variable geometry? Also, that includes what Prof. Thomas mentioned. And if we had this framework, do you think for a second that it would cover what Lewinsky is trying to speak about, glorifying what variable geometry is doing and less of demonization of what variable geometry is trying not to do? Can we have a framework that maybe covers the strengths and the weaknesses, and then enhancing more variable geometry in terms of promoting economic development and not disintegration and fragmentation? And I think this would be a great question that you would take forth and respond. And while you are at that, I would like to read one more question that is in the chat from Emily. She asks, first of all, she thanks the panelists. I'm going to read as it is. Thank you, panelists, for the insightful discussions. My question is on the Kenya-EU EPA. Was the application of the variable geometry in the case of the EPA compliant to the ECJ's advisory opinion? I think, Prof. Thomas, this would be a great question for you to respond now that you touched on it during your presentation. So as Dr. John and Masiko, no, not Masiko, Dr. John, Dr. Esther and Prof. Thomas answer those questions. Tekin, you will be next. I will take your question after that.
Okay, I'll go first. I don't, respectfully, so I don't agree with Dr. Timothy that there should be a framework or there should be any form of restrictions. And I'm actually in support of the AFCFTA because, you see, variable geometry it's like a snake. It takes different forms. We cannot restrict it in particular definitions that we know now. There's a lot of technology coming in. There's a lot of knowledge in the world coming in. we let it flow as it goes. And of course, it cannot be 100% perfect. So I appreciate that there are challenges in implementation. And that's like anything else, you know, even if it was not existing, just integrating on its own is challenging because there are different people, different interests. So that is expected. And the challenges will be addressed. But I want us to note that even if we are struggling to make it better and happen, it's mainly for the future generations that are coming. You know, so even as we are getting ready to ensure we benefit, it's mainly for, let's say, your children and their children. So you prepare them appropriately, knowing that, you know, you don't hold back one person because of another. So I don't agree with Dr. Timothy that there should be a structure or it should be going a certain way. I think it should drive its own way and then it finds its own way. Thank you.
Let me come in response to this. Actually, the concern or the response by Dr. Katende is also including me, not only Professor Tim. What we are saying is the idea is brilliant and noble, that we appreciate different levels of development that each of the partner states has lived. And we look at flexibility as it is. That is the message. But should it go just like an ancient pain, which killed right from the wandering cow to the cabinet minister? We are saying, let it be structured. Let variable geometry, brilliant as it is, but it is like a wild cow. It is uncontrolled, and it has been now subject of abuse. Our proposal is, let there be guidelines, just to be guided, that probably you confine in anticipation as a vaccination for what we have already seen here. I will tell you one simple, small example, Doctor. Look at a certain time, Tanzania, during the time of President Magufuli, had almost lost the interest with the EAC. For them, they were concentrating with SADC. And I remember now, for them, if you would ask them, they would probably even invoke the principle of variable geometry. We have decided actually this to us, this is our area of national priority. He said it, Tim, our area of national priority, this is the one. I think we should guard against that kind of, the consequence, you know what happened? What followed next was EAC to go with EAC secretariat, the staff, were to go without even salary for some time. Now that is national priorities. But if we guide it, much as indeed we wanted to employ this variable geometry, but there should be things they don't. And as we go along, we can even open it. But should we start? We have already started anyway in an open-ended form, but the results, the consequences are not desirable. That's what we are saying. Let's sit down, we look at it together, and we want to involve the people, the citizenry. Let it be involved. We guide this so that we achieve what we intended by including this particular principle. That's all. We are not against it. We want it and we love it more. Personally, I do. But it's as it is now, leaving it to operate as it is now, we may not achieve much. Instead, it may lead us to, you know, failed projects like the ones we have just seen, including the coalition of unwilling. I don't know. Would Professor Thomas say something? You have disappeared, Prof. Oh, you're coming.
I am here. I'm here. Thank you. Thank you so much.
I see Katende smiling.
Yes, I'm smiling because your thoughts trigger my thoughts, and this is always a reason to be happy, something to be happy about. I will start with a with some memory from Dar es Salaam. So I remember Professor Kabudi even before he became the minister for Foreign
Mhm.
Affairs, and he was actually pushing the SADC agenda. Yeah.
Yes.
I remember we had a seminar like that, and he said, "You know what? For us, SADC is integration out of affection, and EAC is out of necessity." Yeah. So for this reason, I think that was some sort of cognitive framework within which the government of Tanzania operated. Now, I would like now to come to the question which was which Faith asked me directly. It was Emily's question, yeah, whether the Kenya EU EPA is in line with the principle of variable geometry. I have not studied this EPA enough to give a definitive answer to that question. But I have some doubts. So if we take the principle of variable geometry the way the East African Court of Justice interpreted it, the East African Court of Justice, just to recall, it said it is a principle of implementation, not decision-making. By the way, I am very curious, where did EACJ take it from? Because most obviously not from the treaty text. Yeah? So there must have been some reason for that, to limit the application of this principle. And actually, the way the Kenya EU EPA is sold, is presented, is that look, it is not a new decision that Kenya wants to integrate with the EU. It is just that Kenya uses another treaty to implement the treaty to which the EAC states had already consented. Yeah, and that would remind us of that structure of variable geometry which the EACJ was insisting on. The other question is whether it is actually the case. Yeah, and then we should look carefully into the provision of this EPA. It is really only the implementation what was agreed with all partner states back in 2014, or it is kind of sort of a new engagement which will not be covered by the variable geometry. That's my point number one. My point number two, if it is even if it is not covered by the principle of variable geometry, public international law operates according to the principle of consent. So if we have a summit decision which was made unanimously, saying that this implementation is a variable geometry, yeah, then we should, then at least there is no violation of international law. There's another question, if it makes sense, yeah, and if the states are not usurping, yeah, usurping the powers of the EACJ, but that's another question. According to the principle of consent, they may do it. Then there is another third point about this. The principle of variable geometry presumes that some states may go ahead and the others that are left behind are not sanctioned, but there is an underlying assumption that at some point they will catch up, which basically means what we now should expect is that Tanzania, Rwanda, Uganda, South Sudan, that they also conclude similar agreements with the European Union, implementing the old EPA. But the way I understand the government of Tanzania, the famous article of late President Kappa, yeah, the government of Tanzania is absolutely not interested in this EPA. Yeah? They simply do not want it. Yeah. So it is not that Kenya has implemented something and Tanzania will join later and other partner states. Yeah. Kenya is implementing something which the other partner states do not, some of the other partner states do not want anymore. And this is not variable geometry, yeah, as understood by the East African Court of Justice. Yeah. Justifiable only under the idea of the flawed idea of consent international law, but story for another day. Then I also had two more comments. I don't know, Madam Moderator, I don't want to be abusing the right of speech which you gave me. May I
Okay.
proceed?
I think you will take any further questions from, I see we still have 4 more questions.
Yeah.
So we can, yeah, we
stop
can
it
take them. Thank you so much. I'm going to invite Tekin Fidel to ask the question that, so this is the thing that we're going to do because we are almost out of time. If you have a question that is to a specific panelist, I think that would be best so that they can take in the questions, process them as each and every one of you is going to ask. So Tekin, you will go first. Then there was a name, but they just lowered their hand. But Tekin, you will go first. Then Harrison Bori will go next. Then Michael Adiado in that line. I will read the questions that are in the chat. So Tekin, please go.
Thank you. I hope I'm audible. So my question is are the member states of the EAC trustable with the principle of variable geometry? And I ask this question in light of the fact that we have two members within the community who are considered as an integral part of the community and have acted in a very peculiar manner in a different treaty, and that is the African Codes on Human and People's Rights, where Tanzania and Rwanda have invoked the denunciation clause only because they had two unfavorable cases. So are the member states trustable with this, principle, considering also the fact that there is a rather strained relationship even between the member states that we consider to have deeper integration. For instance, Kenya and Uganda have been having issues recently regarding oil deals. There's also the Christopher Ayeko case where Kenya has been faulted for trying to negotiate FTAs without involving the other members. So can we really trust the member states of the EAC with this treaty, considering that it gives them a larger latitude to rather ignore the provisions of the treaty and the protocols?
Thank you. We'll invite Dr. Harrison Bori to go next.
Thank you so much, Faith, and the panelists, the esteemed panelists, for the wonderful presentation. It has been really nice to listen to this discussion, and I've enjoyed it quite a bit. So I thank the panelists for taking the time and for accepting our invitation to come and engage with us on this very important topic. Mine is to make a general comment, and hopefully any of the panelists, if there's time, can comment on it. I think when it comes to this principle of variable geometry, there's been a bit of a problem with us in East Africa, and of course, when the EU EAC EPA was negotiated, there was a bit of a problem with Tanzania saying, we are not happy with its content, and I think for very good reasons. And I think Prof. Milej has mentioned former President Benjamin Mkpa's, commentary about that process. And at some point, then Rwanda and later Kenya said, okay, fine, if we can't sign this thing together, we're going to go each party on its own, or each country on its own. And this was coming off the back of EU and SADC having signed their own EPA, excluding some countries which were involved in the negotiation of other EPAs, including Tanzania and the Democratic Republic of Congo, who themselves are already member of SADC. So that sort of was the setup that came through. And then before a lot happened, Brexit happens, and the UK takes the very agreement that was negotiated by the EU with very few changes, I would say, control find EU, change UK, and then presents it to Kenya and says, if you're willing to sign, we are happy for you to sign. And Kenya signs it immediately and very quickly. And of course, you know, the other EAC members, you know, raise a lot of concern with that. And that is happening at the back of Kenya already negotiating an FTA with the US, which, as has been mentioned, already is going to court. And now later, Kenya now has signed the EU EPA, and there's of course concern whether and Kenya has justified all of this. I heard the Minister of East Africa Community in Kenya say the justification is variable geometry. I heard the Permanent Secretary of Foreign Affairs say on his X account that the justification is variable geometry. And therefore, I, in this sense, then tend to agree with Professor Rwangisa when he says, you know, it can be, this principle can lend itself to abuse. And that's why I agree with Dr. Masiko that if it then lends itself to abuse, it should be regulated. Otherwise, our states, as we know them, it's not a bad principle for flexibility. As we know them, will misbehave. And if they're going to misbehave, we have to find a way of regulating that sort of mischief. And I agree that then that is the reason why we shouldn't let it be a hydra, as we had been told. You know, it's a snake that has a million heads. We don't know the next day what it's going to do. And in terms of security predictability, I don't think then we need a hydra, because the next day it will justify a good action, the next day justifies a bad action, and therefore we should be very careful with this idea that we can have a principle that is so broad that it can do anything at whatever time, and we don't know what to expect of it or what it's going to become. Otherwise, I've enjoyed the session, and I thank the panelists for the wonderful, wonderful engagement.
Thank you, Doc. Those are very insightful thoughts. I'm still processing everything that you've said. You know, I would like to invite Michael. Please take a minute to ask your question, so that each of the panelists can also take at least a minute to try and answer the questions that have been raised, because we're really running out of time.
Okay, thank you. Mine is just to try and connect the political ideologies and the geometric symmetric principle. So, for example, when one of the professors talks about the expansion of the EAC, I think there is a conflict ideologies between different leaders who come up to lead the East African countries. So, for example, a leader like Museveni has always been voting for the East African Federation. So, can we put the ideology issue as one of the major issues that affect this principle? Thank you.
Thank you so much. So, final question that is on the chat, so that panelists can take at least a minute or less than a minute to answer the questions. This is from Chepkorir Sambu. Can variable geometry apply beyond economic areas, e.g. security and political agreements? Can Rwanda, Kenya, and Uganda, for instance, proceed with a mutual defense pact under the EAC protocol on defense that requires partner states to all enter into this pact, but only Kenya and Uganda have decided to go ahead with it? I think she's basically trying to get, can we apply variable geometry beyond economic development? And this question is to Dr. Masiko, which actually reminds me that there is a thing with AFCFTA, you know, trying to leverage the AFCFTA and using its flexible integration frameworks to try and implement maybe higher education integration. Can we use variable geometry in this case? So the first person to respond would be Dr. Masiko, then that way. Kindly take less than a minute. Thank you.
Thank you. To answer Chepkorir's question, the short answer is yes. Primarily because there is no limitation on what variable geometry can apply to. So if Kenya, Uganda, and Rwanda decide to implement the Common Defense Pact to the exclusion of the others, there is nothing to say that they cannot do that. However, if we did have those limitations, and those limitations excluded actions such as political and security matters, then they would not be able to do that. I'll just add a quick attempt to answer Fidel's question on whether EAC partner states can be trusted with variable geometry. Your guess is as good as mine, and I will use NCIP as an example, which is why I say without that specific clarification of how the principle is to apply, trust can only take us so far. As they say, when it comes to relationships, love might not necessarily solve all the problems that a relationship may have.
Thank you. Dr. Esther, are you going to take up a question?
No, I still stand as I had stood before, and I would be glad to hear what other people say.
All right, thank you so much. Prof. John Ranga.
Well, I may not have anything more or useful to add. Otherwise, the question by Tekin has been very well answered by Harrison in his observation, and he has just done it on my behalf.
Thank you so much. Finally, Prof. Thomas.
Just a quick one. I think what triggers the need for variable geometry, as was mentioned here, is the fact that the elites cannot agree. Yeah? I think that the elitism of the regional integration in Africa, that it's just elites talking to each other, that Professor Kabudi thinks, well, we are more affected towards SADC than EAC, is quite a decisive factor why we even need thinking of variable geometry. Also, based on what Professor Hangisa has said, we have a deficit of democracy. Yeah, we need more engagement within the EALA, empowerment of EALA, empowerment of civil society and the business community, and then we will perhaps have a better common understanding. Yeah, then we will have a marriage. Yeah, and not each spouse doing his or her own thing. Yeah? So let more people in. Perhaps you would need less variable geometry in our problem will be solved. Thank you.
Yeah, thanks. Just before we conclude, I would like to read Dr. Henry Mutai's comment. He says, "Thank you to the panelists. Mine, his is not a question, but a comment, and he's laughing out aloud." He says, "Much as I appreciate the flexibility argument in favor of variable geometry, my concern is that it reduces a treaty to no more than an MOU. Can we seriously say that Somalia, for instance, has taken on any binding obligations in joining the AAC? I mean, that is very disturbing. But if this is raised, variable geometry would be raised as a defense, and those are his 2 cents. As we conclude, I would like to encourage and maybe say, you know, I wish we could take this conversation further and not make it an academic exercise. Maybe we should be invited to give public education to Council of Ministers in the EAC and tell them exactly what variable geometry is, the consequences that it comes with, the regional integration frameworks that it should, you know, move forward, and even embrace what Dr. Esther says about let EAC tell its own story, and like saying, let Africa tell its own story. If this is a snake that is going to move in particular ways, let it flow. Let us see how this goes, you know. And I would like to thank each and every panelist and each and every participant in today's webinar for your presence, for your contribution, and even for listening. It has been very insightful, and I hope that moving forward, we're taking this and learning so much from variable geometry. So we've come to the end of our insightful webinar on examining the principle of variable geometry and its implications in trade relations between community and third-party states. And I would like to thank you all for sparing your time to attend this discussion and for enriching it with your questions and comments. I would like to specifically and specially express my sincere gratitude to the panelists for their enlightening contributions, and would still insist and remind you of the brief reminder that you are welcome to submit your commentaries and blog posts for the Jumuiya journal and the Usuli Usuli blog. We shall now end the webinar with a word of prayer from Ms. Chepkorir.
Okay, thank you. Yeah, let's go. I thank you, God, for this webinar that has been successfully. Thank you for the panelists who have educated us and for gathering us with the panelists, with the participants. In Jesus' name.
Thank you so much. I would like to say that the webinar is now over, and have a good evening, good day, whatever time it is. Thank you so much.
Thank you.
Thank you very much.
Thank you, Faith. Thank you, everybody. Have a good evening.
Thank you, Prof. Have a good evening.
You too.